Welcome to this deep dive. Today, we're taking a look at a specific legal challenge connected to former President Trump's executive order, the one aiming to ban transgender individuals from serving in the U.S. military. Our main source here is a transcript, actually, from the Ring of Fire channel on YouTube. It focuses on a preliminary hearing.
Right, and what's interesting is how it highlights a U.S. district judge really grilling the lawyers who were defending the ban.
Exactly. It sort of sets up this, David versus Goliath feel almost in the courtroom, a judge questioning the administration's lawyers.
And the core question we're kind of exploring based on this source.
Yeah, what we want to understand is, can arguments that, well, seem like common sense actually stand up against formal legal justifications, especially on such a politically charged issue?
It's a great question. So delving in, the transcript points to Judge Anna Reyes and the central issue she apparently focused on, at least in this hearing. It was the argument about pronouns. The claim that allowing transgender service members to use, different pronouns would somehow negatively impact the military's effectiveness.
Okay, so not necessarily the constitutional arguments yet, but the practical impact argument.
Exactly. At this preliminary stage, that seemed to be her focus. The transcript says she directly asked Trump's legal team something like, would less than 1% of soldiers using different pronouns really affect the, quote, greatest fighting force?
That's a very pointed question. How did they respond, according to the transcript?
Well, apparently the lawyers representing the executive order, they actually agreed. They said, yes, it could have a negative impact.
Wow, okay. So they stuck to that argument.
They did, which then led to Judge Reyes's pretty sharp rebuttal, as described in the source.
What did she say?
She essentially said, look, if pronoun usage is enough to affect military competence, then maybe the military has a much bigger fundamental problem than just pronouns, implying incompetence, really.
That's quite a statement from a judge. It sort of cuts right through the legal argument to the underlying assumption.
It does, and according to the source, she even challenged them further. She apparently offered a box of cigars.
A box of cigars?
Yeah, a box of cigars to any military officer who would actually come and testify, under oath presumably. That pronoun usage makes the U.S. military less prepared.
Okay, that's definitely not your typical legal proceeding detail.
No, and the YouTube commentator the source we're using really seized on this. They described the judge's approach as basically using common sense, not getting bogged down in, complex legal jargon.
So the commentator saw it as a victory for simple logic over what they considered weak legal points.
Pretty much. They praised her directness, and they were quite critical of the arguments from Trump's lawyers. The transcript notes the commentator called the arguments dumb.
Right, and the lawyers themselves incompetent. Strong words.
Very strong. It highlights the commentator's perspective that the whole justification presented by the lawyers lacked real-world grounding.
So it really boiled down to this core question, at least in this snapshot. Does the effectiveness of a massive, powerful military really hinge on pronoun usage for a tiny fraction of its members?
That seems to be the fundamental clash presented in the source material.
Yeah.
The legal argument versus what the commentator framed as a common sense objection.
Okay, so let's recap this deep dive then. The key thing we pulled from this specific source, this YouTube transcript, is this conflict, right?
Right.
You have the legal arguments put forward to defend the ban, citing military readiness, effectiveness, and then you have a judge, at least as interpreted by the commentator, pushing back hard using what they call straightforward common sense reasoning.
Exactly. It shows a real tension between the legal framework and perhaps the perceived practical reality on the ground.
Which leaves us, and you, the listener, with a pretty interesting thought to chew on.
When you hear about these kinds of legal battles, especially the really polarizing ones, where do you draw the line?
Yeah, where's the line between what's presented as a legitimate legal or procedural concern and an argument that maybe just doesn't hold up to, well, practical scrutiny? Does it feel grounded in reality?
And maybe more broadly, what role should this idea of common sense, whatever that means to each person, play when judges or anyone else interprets and applies the law? How much weight should it carry against established legal doctrine?
Something to think about.